All right, good morning, everyone. I'm Judge Jackie Powell. This is First Appearance Court. Today I'll let you know if I've determined probable cause from the police reports I read this morning, and then we will talk about release conditions. Today is not your trial date, nor is it an adversarial hearing, and so I encourage you not to talk about your case on the record, I guess, unless you've spoken to your attorney. For those of you represented by the attorneys in the public defender's office, in the courtroom with me, I do have Mr. Brian Reedy. Over at the main jail is Mr. Adam Goldberg, and these attorneys are available to you by phone, those of you who are at the other locations. If you are represented by private counsel, your attorney will come to the courtroom and address your case from here. If your attorney is not here when I call your name, you can let me know, and I will try and reach out to your attorney. But I am going to ask you, please don't tell me you have private counsel unless you or your family retained the attorney for this recent arrest. Just because an attorney represented you in the past or maybe representing you on a pending matter does not automatically mean that they are continuing to represent you. You or your family have to retain them for each case. Also in the courtroom with me, I have the attorneys from the state attorney's office, and I am going to ask them to announce themselves.
Good morning, Your Honor. Vanessa Terradas on behalf of the state.
Thank you.
Good morning, Judge. Eric Arbele on behalf of the state.
All right. Okay, thank you. And also in the courtroom, I have representatives from confinement status, pretrial supervision, and the clerk of courts. And these persons are here to help with the morning's hearings, and they can provide additional information if needed. Some of you this morning, those of you charged with misdemeanor cases or municipal ordinance violations, you may be able to resolve your case at first appearance, but that is going to be dependent on what's going on with you personally. Those of you who are facing felony matters, those of you who have violation of probation, where the judge already signed a no bond warrant, or if you have a violation of pretrial, where the judge already signed a no bond warrant, those cannot be changed at first appearance. You must go before your division judge to address those issues. All right. We have several people who've signed in this morning, and then we have some persons who need the Spanish interpreter. So let's see if we can handle the Spanish interpreter cases first. Good morning. If you would raise your right hand, you swear or affirm to interpret from Spanish to English and English to Spanish.
I do, for the record, Moises Hernandez, Moises Hernandez.
Thank you, Mr. Hernandez. All right. I have, and I don't have the page number, so if someone will help me with that, it's Darwin Morales Benitez.
Tengo a Darwin Morales Benítez, no tengo el número de página, alguien me ayudará con
Page
eso.
5.
La página 5, Darwin.
That's okay.
All right, Mr. Morales
Bien, señor
Benitez,
Morales Benítez.
you are before the court
Usted
for an
se encuentra ante el
out-of-state hold.
tribunal por una orden de retención de fuera del estado
It's an out-of-state, it's from the state of Texas,
y eso viene del estado de Texas
and it has a no bond hold.
y tiene una orden de retenerlo sin fianza.
You will have to appear before an extradition judge on this matter.
Tendrá que comparecer ante un juez de extradición para atender este asunto.
¿Qué significa eso?
What does that mean?
Okay, hold on just a moment. It means
Significa
that Texas,
que Texas,
you have some pending case in the state of Texas,
usted tiene unos asuntos pendientes en el estado de Texas.
and they have picked you up. The charge, it looks like, is for theft.
Ellos le han acusado y parece que el cargo se trata de hurto.
And so there's a warrant that has been issued for you out of Texas.
Por lo tanto, hay una orden de arresto que emitió el estado de Texas.
And in order to discuss transporting you back to Texas,
Y para poder discutir el transporte suyo de regreso a Texas,
you have to go before a judge to have that conversation.
tiene que comparecer ante un juez para tener esa conversación.
And that is what's called extradition court.
Y eso es lo que se llama un tribunal de extradiciones.
All right, the confinement has a, were you going to say something?
Si puede añadir en el asunto, al final del caso, añadir un número
The letter P
La
on the
letra
case
P.
number? Okay,
al número del caso.
all right.
Muy bien.
All right, next we have Luis Castillo Gonzalez.
Tenemos próximo a Luis Castillo González.
All right, Mr. Castillo Gonzalez.
Bien, señor Castillo González.
You are before the court this morning for one charge of grand theft.
Se encuentra usted ante el tribunal en la mañana de hoy por una acusación de hurto mayor
And I find probable cause.
y yo determino que hay causa probable, motivos fundados para procesarlo.
State,
Fiscalía Estatal,
Your Honor, the state
su señoría, la Fiscalía,
will recommend the bond as is.
recomienda la fianza tal y como ha sido señalada.
if, state, I know that you guys only have one microphone over there, but whoever is speaking, please try and speak in the mic.
Fiscalía sé que solamente tienen un micrófono allá entre ustedes, pero aquella persona que vaya a hablar, por favor, converse directamente al micrófono.
And then my next question is, does Mr. Gonzalez have any priors?
La pregunta siguiente que tengo es que si el señor González tiene algún antecedente penal.
One moment, Your Honor.
Un momento, su señoría.
Judge, it appears in
Pues
2011,
parece que en el 2011
the defendant has
el acusado
an
tenía
arrest from Miami-Dade
un
for
arresto
attempted
de-
felony murder,
del condado de Miami-Dade por intento de asesinato, delito grave,
resisting officer without violence. He was adjudicated.
y por resistirse al arresto de un agente sin violencia, pero ese asunto fue adjudicado.
A 2007 assault aggravated with deadly weapon,
En
adjudicated.
en el 2007, una tentativa de agresión con arma que agravó el cargo,
Battery aggravated great bodily harm, adjudication.
agresión con gran daño corporal, adjudicación.
2006 possession of cocaine.
En el 2006 poseyó cocaína.
2006 assault, aggravated assault.
En el 2006 una agresión agravada.
2005 petty theft.
En el 2007 ratería o hurto menor.
And that is all, Your Honor.
Ahí tenemos todo, su señoría.
All right, Mr. Goldberg?
Bien, señor Goldberg.
We've got nothing to add at this time.
No tenemos nada que añadir en estos momentos, su señoría.
All right, he has a $1,000 bond,
Tiene una fianza de $1,000.
no return to Home Depot
No regresar al Home Depot
in West Park,
en West
in the
Park,
city of West Park.
en la ciudad de West Park.
Okay. Yes. A juvenile. All right, Jose Elias Chavez.
José Elías Chávez.
Mr. Chavez is
Señor
before the
Chávez
court for
se
one
encuentra ante
charge
el
of grand
tribunal.
theft.
Por un cargo de hurto mayor.
Number 2 is a violation of felony probation.
Y el segundo cargo es que haber violado su libertad condicional.
And he has a no bond hold on that charge.
Y hay una orden de retención sin fianza en ese segundo cargo.
That's a no bond hold for Miami-Dade County.
Esa sería la orden de que no se le conceda fianza y se le detenga del condado de Miami-Dade.
I find probable cause.
Encuentro que hay fundamento para procesarlo o causas probables.
He has a $1,000 bond
Tiene una fianza de $1,000
and also no return to a Home Depot in West Park.
y no regresar a Home Depot en West Park.
Ramon Diaz Hernandez.
Ramón Díaz Hernández.
All right, Mr. Diaz
El
Hernandez
señor Díaz Hernández.
is before the court.
¿Se encuentra usted ante el tribunal?
Charge 1 is domestic battery by strangulation.
El primer cargo es una agresión de violencia doméstica mediante estrangulación.
Number 2 is criminal mischief over $1,000.
El segundo cargo es daños a la propiedad con más de $1,000 de daños.
And number 3 is tampering in a third-degree felony proceeding.
Y el tercer cargo es interferencia indebida en un procedimiento de delito grave.
I find probable cause for these charges.
Encuentro que hay fundamento para procesarlo por los tres cargos o causa probable.
I'll hear from the state.
Escucharé de la Fiscalía Estatal.
Your Honor, it appears the defendant
Su
has a
señoría,
2017 prior arrest
Parece que tiene el acusado un arresto en 2017
for sexual battery, aggravated assault with a deadly weapon, false
por,
imprisonment,
por tentativa de agresión con un arma que fue agravado y por aprisionamiento o restricción a la libertad
and battery against the same victim.
y también agresión contra la misma víctima.
State's recommendation is
La recomendación de la Fiscalía será que
a $5,000 bond on count 1,
se le imponga una fianza de $5,000 por el primer cargo,
on count 3, a $4,000 bond,
$4,000 de fianza por el tercer cargo
no victim contact,
y que no haya contacto con la víctima
and GPS monitoring.
y que se le monitoree con un artefacto electrónico.
Did you say the sexual battery charge was against the same victim?
Yes, Your Honor.
Dice usted que el delito de agresión sexual fue contra la misma víctima, sí, su señoría.
All right, Mr. Goldberg.
Muy bien,
From what
señor
he's told me, he does have
Goldberg.
some family here in the area.
De lo que él me dice, tiene familia aquí en la zona,
Judge, he's got a sister,
tiene una hermana,
some
juez,
children.
y niños.
He's lived for the last 4 years in Pompano.
Ha vivido por los últimos 4 años en Pómpano.
He works doing construction,
Se dedica a la construcción como obrero.
and the work is up and down.
El trabajo va y viene.
So I think he's going to have some difficulty posting whatever bond the court sets.
Me parece que tendrá dificultades en postear la fianza que el tribunal le establezca.
So Judge, in light of that, we'd ask for the lowest reasonable bond for him.
Por lo tanto, su señoría, le solicitamos la fianza más baja posible que sea razonable para este caso.
Nothing further, thank you.
Sometido.
All right, and in reviewing the probable cause affidavit
Bueno, al repasar la denuncia de causa probable
and listening to the priors involving the same victim,
y escuchando los antecedentes que tienen que ver con la misma víctima,
at this time, I am going to impose a $10,000 bond on charge number 1
a esta fecha voy a imponer una fianza de $10,000 por el primer cargo
and a $5,000 bond on charge number 3.
y $5,000 de fianza por el tercer cargo.
The bond on number 2 will remain as a standard bond.
La fianza que hay sobre el número 2 permanecerá inalterado.
If Mr. Diaz Hernandez posts his bond, he'll be on a level 1 pretrial supervision.
Y si el señor Díaz Hernández logra postear la fianza, se encontrará bajo un nivel 1 de supervisión con antelación al juicio.
No victim contact,
no debe tener contacto con la víctima.
And that means no phone calls,
Eso quiere decir que no hayan llamadas telefónicas,
no text messages,
nada de mensajes de texto,
no social media,
ningún medio social,
no third-party contact.
ni comunicación o contacto por terceros.
Do you understand that, Mr. Diaz Hernandez?
¿Entiende usted eso, señor Díaz Hernández? ¿Entiende
Sí.
usted? Yes.
Okay. All right, Carlos Jose Perez.
Carlos José Pérez.
All right,
Y
Mr.
el
Perez
señor Pérez,
is before the court this morning for an ad charge.
usted se encuentra ante el tribunal en la mañana de hoy porque se le va a añadir otro cargo.
That is now charge number 5,
Ahora se convertiría en la quinta acusación.
false ID given to a law enforcement officer.
Y eso fue por presentar una identificación falsa ante un agente del orden público.
I find probable cause,
Determino que hay motivos fundados para procesarlo
and he has a $100 bond on this charge.
y hay,
100.
y hay una fianza de $100 por este cargo.
All right, is there anyone else who needs a Spanish interpreter?
¿Alguien más que necesite intérprete de español? Levante la mano.
Not here in the main jail, Your Honor.
All right, thank you.
Thank you, Judge.
All right. There are a few people that the jail asked to call out of turn, so let's address those persons now. Sean Legary on page 6.
Here is.
All right, Mr. Legary is before the court on one charge of touch or strike battery. It's domestic violence. The court finds probable cause. Does Mr. Legary have any priors?
Your Honor, I see no Florida priors. State's recommendation would be, based on the facts, a bond of $1,500 and with no victim contact.
Mr. Goldberg?
Judge, he's told me that he can stay at his father's house in Miami Gardens. He's lived here in South Florida for the last 34 years. He lives in Miramar. We'd ask for the lowest reasonable bond for him. We'd also ask for a photo order as he sustained some injury, as well as an order allowing him to return to the property one time with law enforcement so he can retrieve some personal property.
Based on the allegations, I am going to impose a $2,500 bond. No victim contact, and at this time, I'm not going to, he's not able to return to the home at this time, not even with law enforcement.
Judge, the only issue is that the residence that he's going to stay, which is his father's house, the key to that residence is at the current home, and so he would need just to get that key so he can go stay at a different location.
Well, where
which
is the
his
person
father-
that lives at that, where is the person who lives at that location?
I don't believe anybody lives there. That's his father's home, but it's an empty house.
Without further information and further testimony, I'm not granting an order to return.
Do you need testimony from
No.
Mr. Laguerre?
Not today. They're not gonna do that today. Corey Knight?
Judge, this is Mr. Knight on page 7.
Mr. Knight is before the court on one charge of battery causing bodily harm, domestic violence. I find probable cause.
Your Honor, the state would be, based on the allegations and on the fact that Mr. Knight has a pending battery where he has a pending open battery at this time where he's accused of attacking his ex-girlfriend's boyfriend. The state's recommendation would be bond of $5,000 with
State, can you repeat, please? Can you speak into the microphone?
the state would be requesting a $5,000 bond with no victim contact.
Judge, for Mr. We're requesting both a photo order and a phone order for him. From what he's advised me, he does not live with the alleged victim. He lives in Pompano. He's lived there his whole life. He's not working. His dad, I'm sorry, he's self-employed. He works setting up art shows. His dad stays with him. His dad is not working, and so he's going to have a real hard time meeting that $5,000. We'd ask the court to set bond in the amount of $1,000.
All right, Mr. Knight has a pending battery case, and in light of that, I am going to grant the $5,000, no victim, a bond, no victim contact, which means no phone calls, no text messages, no social media, no third-party contact. Marshall Gray? All right,
We're ready, Your Honor.
Mr. Gray is before the court this morning on one charge of aggravated battery with a deadly weapon. It's dating violence. I find probable cause. State?
Your Honor, based on the fact that he does have a prior battery in 2011, he was adjudicated guilty of domestic violence. The state would be requesting a bond of $10,000 with no victim contact.
Judge, we'd be asking for a photo order for Mr. Gray, and also an order allowing him one time to return to the property so he can retrieve some personal property. He says he's going to stay with a friend in Fort Lauderdale. Mr. Gray has lived here since 1982. He's got some cousins in the area. He works right now as a roofer, and he makes $800 a week doing that. Based on that, I don't think he's going to be able to afford that $10,000 bond. So we'd ask for a bond that's less than what the state is seeking.
All right, I am going to deny the return to pick up personal items. These allegations are that Mr. Gray poured lighter fluid on the alleged victim while holding a lighter and told her that he was going to light her on fire. Based on those allegations, I am not signing an order for him to return. And I am going to impose a $10,000 bond, and I am going to order no victim contact with a 500 feet stay-away order. Do you understand that, sir?
Yes, ma'am.
No victim contact means no phone calls, no text messages, no social media, no third-party contact.
And Your Honor, I apologize. He is classified as a habitual offender. If we could also add a monitor, GPS monitor.
When did he receive that classification?
In 2011, Your Honor.
All right. He'll also be on a level 2 pretrial supervision. All right. All right, Mr. Plant. Good morning. All right, on page 2, it's a municipal ordinance matter, Billy Brown. No, I'm sorry, page 2, Mr.
Amber Wright, North Broward. For the city cases.
Amber Wright.
This right is a medical reset.
There's just one left.
Oh, so Amber Wright is a medical reset,
Yes, Your Honor.
okay. And then Billy Brown on page 10.
He's in Maine.
Billy Brown
Brown.
on page 10.
It's the city of Pompano, Your Honor.
Resolved, Mr. Mayor. That's your attorney right there.
All right, Mr. Brown, you are before the court on a municipal ordinance violation for solicitation, and I find probable cause.
Can I resolve this morning?
You certainly can. You'll be sentenced to time served. Do you wish to?
Yes, ma'am.
All right, Mr. Brown, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And, Mr. Brown, you understand the offer of adjudication time served to resolve your case?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it will subject you to deportation or immigration changes?
Yes, ma'am. I'm a U.S. citizen.
What plea do you wish to enter at this time, guilty or no contest?
No contest, Your
I
Honor.
accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, Mr. Brown, is adjudication time served, and I'll give you 6 months to pay your court costs.
Okay.
All right?
Look, sir.
All right, Mr. Plant, that's it for you. All right. Same to you. All right. On page 6, Quantavian Johnson. All right, Mr. Johnson is before the court, one charge of touch or strike battery, it's dating violence. I find probable cause.
Your Honor, based on the fact the state will be requesting a $1,500 bond with no contact and with a shows that he has 2017. Even though it was dropped out of my date, he had a charge of grand theft until firearm or weapon. So the state will be requesting no weapons, no ammo, in addition to no victim contact.
Who are you? Are you the alleged victim in this case? You have to speak so that I can hear you, okay?
Ma'am.
Is there something that you wanted to say today on the record? No, answer that question. Is there something you want to say, yes or no?
Yes.
All right, and so I need to let you know that, you don't have private attorney, representing you here today. And so everything you say on the record is being recorded and as well can be used against you. So knowing that, do you still wish to speak on the record? All right, then I'm gonna have to put you under oath, so I'm gonna ask you to raise your right hand. Do you swear or affirm to tell the truth? All right, and then you can put your hand down and please state your full name for the record.
Tanzania Dali.
I I'm having difficulty hearing you.
My name is Tanzania Daly.
Okay, Ms. Daly, what is it that you wish to say?
I just want to know, is it possible for the bond to be lowered?
Okay. All right. Mr. Goldberg?
Judge, from what Mr. Johnson's told me, he does not live with the alleged victim. He's lived in South Florida his whole life. He just stopped working. He was working seasonal work for UPS, and that just ended with the holidays. He's hoping one day to enroll in the military, and as the witness is advised, he himself says he's going to have a hard time with the bond, so he would also ask for. He said the most that he could afford is $100 to post bond.
Ms. Daly, are you going to be the one posting his bond?
Yes, ma'am.
All right, I am going to impose $1,000 bond and no victim contact until further order of the court. And that means no phone calls, no text messages, no social media, no third-party contact. That is in place until a judge signs an order saying that no contact order has been lifted. You understand that?
Yes, ma'am.
Mr. Johnson, okay.
Your Honor, what about the?
No weapons or firearms, no possession of any weapons or firearms also. Do you understand that, Mr. Johnson?
Yes.
Okay,
I have a question.
Yes, ma'am.
Is it 1,000 or is it going to be half of the?
it's $1,000. You have to speak to a bondsman in regards to how that is, paid. Okay? All right, on page 8, Nicole Latouche.
Judge, he's present and approaching. He declined the services of the public defender.
All right, Mr. Latouche, you understand, sir, that you are entitled to an attorney at this hearing?
Yes, ma'am.
And are you saying that you don't want to have an attorney at this hearing today?
No, that's not what I'm saying. The lady asked me if I want to hire a private attorney, and I said yes.
Well,
I'm not
that's,
familiar with the legal processes.
well, that's a different thing. Today, you are entitled to an attorney for this hearing.
Okay.
If you want to hire a private attorney, that's certainly up to you, but the attorney is not available at this hearing.
Yeah, that's. No. She asked me if I want to hire a private attorney. I said,
Hey, how are you? Are you here on this case?
Yes,
Oh. Oh, the bondsman is here on this case.
but it's good if he uses the PD.
Well,
I'm
what,
not sure if the state is
well,
gonna be seeking.
what message do you have today? It is a first-degree felony.
Yes, I think the property was his mother's, and she owns it, she's paying rent. He lives there, she actually gave the house to him. She has 2 houses, so it's kinda hard to be a burglar if you own the property. No, I'm not, I'm just letting the state know. Letting the state know. Just letting the state know, just in case they wasn't aware.
I think I'm gonna have to send you to law school.
Well, you leaving, so I might as well get the last one in.
All right, so, has Mr. Latouche decided what it is that he wants to do as far as an attorney this morning?
Judge, at this point, it looks like he's gonna complete a public defender application, and so we'll represent him this morning.
Okay. All right, so, Mr. Latouche, you are before the court this morning on a charge of burglary with assault or battery. And for your information, sir, that is a first-degree felony. Number 2 is a touch or strike battery, which is a misdemeanor case. All right, so I find probable cause for these charges. And I will hear from the state.
Your Honor, the defendant has a 2009 resisting without violence, VOP, and he was arrested for battery on a law enforcement officer.
In 2009,
Yes, Your Honor.
it's interesting that the first thing Mr. Latouche said when he came up is that I don't understand these proceedings. Okay, is there anything else?
Fires. That the charge is punishable by life. The state would ask for a no bond hold, and the state would ask for Your Honor to find proof evident presumption great.
Judge, we would object to the court making a finding of proof evident presumption great at this point in the proceedings. That is the highest burden of proof that we have in the criminal justice system. The state has called no witnesses. They've introduced no evidence. As the bondsman has indicated, there's obviously much more to the story as far as whether or not this actually is a burglary. I think based on that representation alone, Mr. Latouche should be entitled to a bond on this case. If over our objection, the court finds that Mr. Latouche, the evidence is, the proof is evident and the presumption is great, we would ask the court to exercise its discretion and set bond for Mr. Latouche.
So I have allegations that Ms. Quarry advised she was putting her 2-year-old daughter, that they share in common in her vehicle, and that the defendant got into a verbal altercation with her, then grabbed her cell phone from her, smashed it on the ground, said to her, "You're living in my mother's place and need to get out." He then began pulling on her shoulders, tugging on her arm as she entered the driver's seat of her vehicle. Once Quarry entered the vehicle and sat down in the driver's seat, the defendant reached into her vehicle, grabbed her around her neck, and began choking her. He said to her, "If I had a knife, I would slice your throat." Ms. Quarry stated that as she was being choked, her airway was not impeded. She did not lose consciousness. She did advise she was in fear for her life as he was choking her and began hitting the car horn, screaming for help. She sustained a few scratches on the left side of her neck, ultimately 2 inches long as a result of the battery. He then backed away and went into his vehicle. She drove her vehicle out of the parking lot to get away from him, and as he drove alongside her, that's when she contacted 911. So, I disagree. The burglary stated that she was in her vehicle, so I find probable cause. I am going to make a further preliminary finding of proof evident presumption great. And Mr. Latouche will be held no bond on that charge until further order of the court. And he'll have a $1,500 bond on charge number 2, and no victim contact. And no victim contact means no phone calls, no text messages, no social media, no third-party contact. Okay. A proof evident presumption grade is without prejudice for him to have a bond hearing based on state v. offer before his division judge.
Thank you, Your Honor.
Right? can't find a John Pierre. Do you have the docket? Do you have a John Pierre on page 16? Is it, the right, that's my question, is it? So who signed in on John Pierre? Well, Mr. Pierre's not going to be here, he's going to be before his division judge. What division is it? That I don't know. It's a lot of, okay. All right, on page 6, Nicholas Skelta. I tell you already, you have the cutest assistant. She's
I'll
such
take
a,
over the business.
she's such a lady. I'm watching her sitting over there.
Thank you.
All right, so Nicholas Skelta on page 6. Mr. Skelta is before the court on one charge of touch or strike battery. It's dating violence, and I find probable cause.
The state will be requesting and specifically the part where the victim stated that this was not the first time. State would be asking for a $2,000 bond, no victim contact, and also a request of surrender. So this prior, she does have a prior carrying concealed weapon. Even though that charge was declined, the state would be requesting the surrender of all weapons.
On behalf of his dad, Anthony,
Okay?
I know he's only able, he referred to me $1,000 bond, which is $100. He's able to post.
Okay. All right, so I'll grant the $1,000 bond, no victim contact. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, Mr. Skelta? You understand?
Yes, ma'am.
And you also, if you have any weapons or firearms, those need to be surrendered. Do you understand that?
Yes, ma'am.
All right?
That's after he gets released? or-
Yes.
Okay. All right. Thank you, Your Honor.
Okay. You too. Hold on just a moment. Don't go ahead. Hold on. I'm just gonna take a brief recess. All right, let's continue with Shakardra Bailey Robinson. And make a note. All right, Miss Bailey Robinson is before the court on one charge of criminal mischief, and number two is trespassing, and I find probable cause. What does Miss Bailey Robinson want to do?
Well, Judge, I was going to ask the court for pretrial release for Miss Bailey Robinson. She's been living in South Florida for the last 2 years. She has a job as a cashier at the Hard Rock Cafe. She has a place to stay, stable residence, and this is a nonviolent offense, I guess, and, well, maybe not so much, but I guess it was an argument. But I believe she's a good candidate for pretrial release, Judge, and she really doesn't have any money to post a monetary bond.
Stay, do you wish to be heard?
Yes, Your Honor. The defendant has a 2017 prior uttering forged instrument grand theft where she served 60 days in jail. (2013) no valid driver's license. 2011 petty theft. And she was also arrested for aggravated battery. The state would ask that Your Honor keep the bonds.
She ever been on pretrial? Do you have that information?
She really just doesn't have the $50 to bond out, Judge.
Okay.
She also has a pending 2019 dealing in stolen property, grand theft, and driving while license suspended.
There's a pending matter.
Yes, Your Honor.
She posted bond on that case.
One moment, Your Honor.
Okay.
Your Honor, she was on pretrial release on the 2019 case. That's pending.
On the pending case, she's on pretrial. Well, lots of things have changed. She's on pretrial supervision. On, is it a felony case? Does Miss Bailey Robinson, do you have a permanent address?
Yes, ma'am.
I'm sorry?
Yes, ma'am.
It's something that can be verified if somebody calls?
Yeah, but my granddaddy old, so we really can't hear, but you could go to the place, to the house.
When you say he's old, how old is he?
He's 79.
Is that where you live now?
Yes, ma'am.
Who else lives at the house?
Just me, my granddaddy, and my brother.
All right, I am going to put her on level 2, pretrial supervision, also on the pending case. So I'm gonna change that to level 2 pretrial. All right, so, ma'am, I'm gonna place you on ankle monitor, and then the pretrial office will have to verify your address and all that information and fit you for an ankle monitor. and you'll be on pretrial release level 2, both on this new arrest and that the other case that you were previously on standard pretrial. I'm changing it to level 2. Do you understand that?
Yes, ma'am.
They'll come and interview you to get all the necessary information so that they can verify the information. Okay?
Okay.
All right.
All right. Good luck, Miss Bailey Robinson.
Thank you.
Marie Fleur Engeville.
No prior, Your Honor, she's approaching.
All right.
Good morning.
Good morning, Ms. Engeville. You're before the court. You have a misdemeanor capias, and you also have a violation of pretrial on a misdemeanor case, and that judge set the bond at $5,000. And you will have your hearing before Judge Evans on Monday at 8:30 a.m. I find,
What is, will I be getting set free or an ROR?
no ma'am.
No.
You'll have to go, you either have to post your bond, you have a total of $10,000 in bonds, or on Monday, you'll see your division judge.
Okay.
Remember we talked about this, Miss Angeville? That Judge Powell can't do anything about the $5,000 on the warrant for the violation of pretrial release. You
I
have to,
thought you said if the whole thing was 10,000, 10% needed to be paid, well.
yeah,
you
you
told me
can
that.
bond out. Your bond is $10,000. But
Yes, I
don't
can
forget, if you bond
out.
out, you still need to be in front of Judge Evans on Monday.
Okay, so
Okay.
when I go before him, he has the verdict of what's gonna happen, of course.
Essentially, yes, that's correct.
Do you have any idea what he might
No,
do?
I have no
Because
idea.
of my charge?
I have
No
no idea.
ma'am, no ma'am. When you go before Judge Evans, you'll
Just
have that,
asking.
we can't tell you what somebody else is going to do. Okay?
Yeah, I don't know. You know? Right.
All right, Serena Mitchell.
Thank you.
Bonded, Your Honor.
All right, Ms. Mitchell bonded. I find probable cause.
Yeah.
Which one? Yes, I did. I pulled it out and thank you. Mr. Goldberg, who's standing next to you?
Hi, Judge. This is Miss Arthur on page 1
Okay.
of the docket.
All right, Middleton Author. And Ms. Author is before the court on one charge of touch or strike battery. Number 2 is abuse of child without great bodily harm. Number 3, driving while license suspended without knowledge. That's not for magistrate. I find probable cause. State.
Just pulling up her priors. It appears she has no Florida priors. The state's recommendation would be on count 1, the battery.
I'm sorry, the last thing we heard was no Florida priors.
Sorry, on count 1, the battery. $1,000 bond. On count 2. $3,000 bond. And no victim contact.
Judge, we're hoping that the court will be inclined to reduce the bond on count 2 in light of the fact that she has no prior record. She's going to reach out. I'm going to reach out to her mom to help her post her bond. She does not live with the alleged victim on count 1. As the state said, she's got no Florida priors from what she's advised me. She's lived here in South Florida her whole life. In addition to her mom, her dad is here. She's working. She works at Ross, and she's also in school at Broward College studying criminal justice. Last time she went to school was right before the break. Obviously, they're on holiday right now. So we'd ask the court to set bond on count 2 in the amount of $1,000 instead of $3,000.
All right, $1,000 on 1 and 2, no victim contact. Okay. Marlene Garral. Is she still in custody, or is she out? Garral? No. Marlene,
North Broward, Your Honor.
all right. No, Marlene Garral has bonded, and I find probable cause. And then Bobby Haslam is at North Broward. Paul Ryan. All right, Ms. Haslam is before the court on a KPS on a felony matter. It is for a change of charge. Steve, do you know what the original charge was? It says change of charge to possession of cocaine. Okay. All right. Is she being held on anything else?
She has an ROR on count 1, and it appears that she's waiting for entry into the SAP program on counts 2 and 3. Is that right, Ms. Haslam?
I've been in the SAP program since December 26th.
Okay, so you're in the program now.
Yes.
Okay.
All right, so just so you understand, you're only here for this one charge where originally it was possession of MDMA. They've changed it to possession of cocaine, okay? And
Yes.
at the MDMA, when it was MDMA, she was ROR'd on that count, is that correct? All right, so I will keep that in place on the new change of charge. So I'll ROR you on that, okay?
Thank you, Your Honor.
All right, good luck.
Thank you.
Tatiana Gonzalez.
Also Paul Ryan, Judge.
All right, Ms. Gonzalez, you're before the court for an ad charge. This is charge number 6, and it is a grand theft charge.
Judge, Ms. Gonzalez has a no bond out-of-county hold, so I just asked the court to leave the bond in place.
All right, so I find probable cause, and you have a $1,000 bond. Tammy Smith.
North.
All right, Ms. Smith is before the court on one charge of battery on a person 65 years or older. And I find probable cause. Okay, state.
The state would ask for $10,000 bond based on the facts of the case, as well as she has a 2017 prior arrest for aggravated battery with a deadly weapon. She has a 2010 possession of oxycodone case, unlawful use of false name, 90 days prison, 18 months probation, 2012 resisting without violence and possession of cannabis, 45 days jail, 2010 trespass, the state would also ask for no victim contacts.
All right, Mr. Goldberg.
Judge, we were going to ask for something substantially less than that. Ms. Smith is going to have a difficult time affording whatever bond the court sets. From what she told me, she does not live with the alleged victim. She has lived here in South Florida all of her life. She lives in Fort Lauderdale with her boyfriend. She's lived at the same place for the last 2 years. Her parents are in the area as well, both mom and dad. And though she herself is not working, her boyfriend does work. He fixes cars. Judge, we were going to ask for a bond in the amount of $1,500.
Well, the allegations are that an argument over $20 that Ms. Smith became aggressive, struck the alleged victim in the face with a fist several times. He had a laceration inside his bottom lip, causing bleeding. Additionally, she had a knife in her hand and demanded for the $20 or she will kill him, and stated that she had the knife in her hand and she was searching through his pockets and took his wallet. I am going to impose a $5,000 bond and no victim contact, which means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, Ms. Smith?
Yes.
Okay. All right, Yasmin Smith.
With Brett.
All right, good morning. You are before the court for one charge of burglary, occupied structure unarmed. And I find probable cause.
Judge, I'm going to be asking for pretrial release for Ms. Smith. From what she advised me, this was a house that was under construction, and I think that is alluded to in the probable cause affidavit that there was a construction crew there. She's been living here in Florida for the last year. She has a permanent address. She has a permanent address with her friend, whom I'm going to call to hopefully, if the court does not grant pretrial release, may be able to come up with some type of a bond.
All right,
But
State.
if her prior record
I'm
isn't
sorry.
too bad, I would ask the court to consider pretrial release.
All right, State.
Your Honor, it appears the defendant doesn't have Florida priors. The state would be asking for a $3,500 bond.
I'm sorry, she has what? If the home was under construction, there's no allegations that it's her home or that she lived there. And the homeowner was at home at the time. She made it all the way up to the second floor. And that she was checking on doors inside of the home. So I am going to impose a $5,000 bond at this time and no return to that location, no victim contact.
I'll make those phone calls for you, Yasmin.
$5,000?
Yes, ma'am. All right, Gainsley St. Fleur.
Excuse me? Excuse me?
Yes, ma'am.
I was supposed to have court today for an old thing. Can you let them know that I was in jail so I don't have a warrant for that?
I don't have any way of telling them, or whoever them is, that you have court, but,
It's in Miami.
well, it's in Miami. I don't have any way of doing that. That will reconcile itself. Gainsley St. Fleur. Mr. St. Fleur is before the court on a charge of assault, it's domestic violence, and number 2 is criminal mischief. I find probable cause.
Top one, the state's requesting a $1,000 bond. That's to count two. State's also I also showed that he has a 2016 domestic violence battery, and a 2015 domestic violence battery. Give me one moment, just trying to figure out if those are the same victims. But that's, as far as the price go, both of those were declined, Your Honor.
Okay. All right, Mr. Goldberg?
Judge, what was the state's recommendations as to bond on this case?
$1,000 on each count.
Judge, Mr. St. Fleur is asking if the court will release him on his own recognizance. He is very much eager to have his day in court regarding these allegations. He's going to go stay with his brother in North Miami Beach. He's lived here in South Florida his whole life. He does landscaping work, part-time though. He said the most he can make out a good week is $200. If the court is not inclined to release him on his own recognizance, we'd ask if he could be placed on pretrial, standard pretrial release, so he can go stay with his brother.
For the record, Your Honor, the both prior batteries that were declined, there's two victims in this case, both his parents. For each case,
I'm sorry, we can't hear the state attorney.
there's two victims in this case, which are the defendant's parents. For the two batteries, one was the father, and the other battery was the mother.
This case, the allegation says that the defendant asked the mother would not give her son $5, and so an argument escalated, and the son began to yell and demand the money. The defendant then began to intentionally break a closet door in the hallway. The officer did observe the door to have a damage to the top hinge side of the door and the frame being cracked. Damage to the door is valued at $150. The parents, both the mother and father, retreated and locked themselves in their bedroom when the defendant intentionally kicked and broke the bottom hinge side of this door. The officer observed damage to this door and frame as well. Damage to the door and frame valued at $150. There was fresh damaged wood observed on the floor behind the door. During the course of the argument, defendant also intentionally slammed a cooking crock pot on a kitchen counter. The crock pot was broken and damage was valued at $75. There's also a kitchen trash barrel that was dented. It should be noted that the father is handicapped from a previous stroke and uses a walker to get into the bedroom due to his fear for his son. Those are the allegations that I have before me this morning, and with the information that there have been prior incidents with the same two alleged victim, I am going to impose a $2,500 bond on charges 1 and 2.
I'm sorry, Judge, we can't hear you.
No victim contact. $2,500 on each count. No victim contact, no return to that location. And I am going to order a 500 feet stay away. Do you understand that, Mr. St. Fleur?
Yeah, Judge, I understand. Can I say something?
Right, I'm not hearing, so I guess you don't want me to hear, so let's move to Gerald Magnus.
Thank you, Judge.
Okay.
All right, you can sit down. I want to talk about the...
Gerald Magnus.
Period.
Mr. Magnus is before the court on 3 misdemeanor cases. For not showing up for arraignment both times, June 12th, and June 20th. And resisting officer without violence, possession of cannabis, 20 grams or less, and a battery charge. So I find probable cause, Mr. Magnus has court on January 6th and January 7th on both cases.
Judge, he's asking if the court would be inclined to resolve both of these cases today.
Well, no, I'm not inclined to do so. One charge is a battery charge, and
Judge, what about, I understand as to count 3. What about the case that's counts 1 and 2, which is a resisting without violence and possession of cannabis?
well, does the state have an offer on on the other case? All right, he'll see his judges next week. Daniel Foote.
Judge, Mr. Foote is present. He's declined the services of the public defender.
I misunderstood as well as the other person, that I put.
I'm sorry, Judge, we're ready to proceed.
All right, Mr. Foote is before the court on one charge of touch or strike battery. It's domestic violence. I find probable cause.
Your Honor, the state will be requesting a $2,000 bond based on the facts. And in addition, to this priors, he does have a 2013 battery that was no price in Miami-Dade, same victim. He also has a 93 resisting without violence and 92 neglectful treatment of a child. That was a treatment issue with health. Based on those factors, the state will be asked for a $2,000 bond.
What is the year of the prior with the same victim?
That was in 2013.
2013?
Yes.
Okay. All right, Mr. Goldberg?
Hi, Judge. Mr. Foote has advised me that he has lived here in South Florida for the last 35 years, the last 25 of which has been in Miramar. He works for APPI Sheet Metal Fabrication. He's a factory worker, and so we would just ask for a standard bond for him.
All right, $2,000 bond, no victim contact. Okay.
Judge, could you call Emma Perea? She's on page 4. She's at North Broward.
We haven't gotten to her yet. Oh, we are past page 4. Right, does the note say sent to division? Because I don't have those paperwork. Okay. She has to go before a division judge, Mr. Reed.
Okay.
All right,
Let me just
Caesar,
let them know up there.
yes, Caesar Polito.
Hey, Deputy, yeah, Emma was sent to division. Okay? She can go back. Tell her I'm gonna try and get her in front of the judge.
Judge, I think if we, can we play Mr. Polito's case on recall?
Okay. Sean Rich, do we have Mr. Rich today?
Yes, Judge, I think we do. North Broward, Judge.
North Broward, Sean Rich. All right, Mr. Rich is before the court on one charge of touch or strike battery, it's domestic violence, and number 2 is resisting officer with violence. I find probable cause.
Judge, it's my understanding Mr. Rich does not have the capacity to post any kind of a monetary bond. I believe that there will be no problem with him staying away from the alleged victim in the case and not contacting the victim in any way. But a monetary bond, I think, is going to be beyond him. So I'd be asking the court to consider a non-monetary release.
All right, State. It's on a no bond hold with Judge Colra. When did that happen?
What all I was charged with, ma'am?
He was adjudicated guilty on that. Several trespass, where he was found adjudicated.
All right,
With that
well,
being said,
if he's on a no bond hold, anyway,
Yeah, so with that, for count one, state requested $2,000 bond, and for
so, I'll impose $1,000 bond on one and $2,000 bond on two, no victim contact, and, Mr. Rich, you have other issues also, so
I
you.
know, but they got me, they arrested me on 4 charges I see on my printout. They say got me for, extortion, threat, or something like that.
No, that's not before me today.
You know what I'm saying? That's one of my new charges.
All right, so here's the problem.
They got me on 4 new charges. They got me on the, touch and
When
strike
they,
battery.
okay, sir, hold on just a moment, okay?
Okay.
All right, so when they give me the new determination form, it doesn't have the other 2 charges on there, which is the municipal ordinance violation and the extortion of threat.
Yeah, so, were those being dropped?
No, those have not been dropped. And I do have it on my booking, report. So, yeah, so let me write the municipal ordinance. Yes,
So there's
yes.
two.
And here's the extortion.
So there's 2 misdemeanors and 2 felonies.
Hold on just a minute. Extortion threats. So, yes, so you have a 1 state charge, 1 municipal ordinance matter, and then 2 felony charges. Okay?
So it's 2 misdemeanors and 2 felonies.
Yes, sir.
Okay.
All right, so, I'll ROR on the municipal ordinance matter, and then on the extortion, charge,
Did you find probable cause for that?
I find probable cause for that. 'Cause
But
there
you
is,
just ain't have it on your thing.
well,
Hold on, Mr.
no.
Rich.
I have it there. The allegations are that you told the deputy that he would not live to see tomorrow, that you're gonna put $100,000 hit out for him. So I have facts that support that, and it is on the paperwork. All right, and so on the, charge number 4, which is the extortion and threat charge, I am going to impose a $5,000 bond.
That's $5.
All right, so you have a total of $8,000 in bonds and no victim contact. Okay?
All right.
All right. Okay, Holton Vassal. All right, Mr. Polito, Cesar.
Please decline the services of the public defender.
All right, Mr. Polito, you understand that you are entitled to counsel?
I ain't declining, I just put you have a lawyer back here, can you help me out? Yes, ma'am, I have a lawyer.
Mr. Polito, so let me explain something to you. You can't have it both ways. So this is why I say, did you retain an attorney? Did you hire an attorney for this arrest?
Not for this.
Okay.
Not for this particular case.
So you don't have an attorney for this particular case. So
No.
that's where we
That's what I
start.
was trying to explain to
Miss-
him, but
If you will just stop and listen, so we'll get there. Okay? So you don't have an attorney for this case, So my next question is, do you wish to use the attorneys for the public defender's office for this arrest today?
Yes.
Well, then
So
you need to have a conversation with them.
I was trying to, but he walked away. He went to talk to everybody else.
All right. Well, if you say I have private counsel, but I just want to use you, that's not how it works. You obviously, you don't have private counsel for this charge, so you don't have an attorney. So that's where they have to start. You can't say I have private counsel, but I want to use you. Did you retain an attorney? And so the answer is no. So, Mr. Goldberg, I guess he needs to speak with you. Or maybe if you have already spoken with him.
Sure, Judge. I'm gonna have to place my recall though, so I can speak to him.
All right, so let's do that.
Thank you, Your Honor.
And then let's go to Holton Vassell.
We've got Mr. Vassell on page 10.
And Mr. Vassell is before the court on a trespassing, unoccupied structure or conveyance charge. I find probable cause. What does Mr. Vassell wish to do?
Thank you, Your Honor. He's advised that he'd like to resolve today if possible.
All right, State, you have an offer for Mr. Vassell?
The state's offers an adjudication in time served.
Right, it's adjudication time served. Does he wish to accept that? Does he have priors? Oh.
And set 1-year probation.
If you'd like to accept the state's offer and resolve today.
Okay, thank you, State. I just wanted to see if there was a basis for the adjudication. All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, Judge.
Okay, you can put your hand down. Mr. Vassell, do you understand the offer that has been extended to resolve your case today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No,
Are you under the influence of drugs or alcohol?
no,
Do you need any more time to speak with your attorney?
no.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No,
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
yes, ma'am.
What plea do you wish to enter at this time, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication time served. I'll give you 6 months to pay your court costs. I'm also ordering and as well reminding you no return to the Seminole Classic Casino. Do you understand that?
Okay.
All right.
Yes, ma'am.
All right, Robert Lee Cyrus.
Judge, he's coming up and he too would like to resolve this matter.
All right, State, you have an offer for Mr. Cyrus?
Your Honor, the state's offers an adjudication, court costs, and no return to Abco Food Market at 56 Northeast Eller Street in Deerfield Beach.
I'm sorry, State. Can you repeat the offer, please?
It's adjudication time served, no return.
We'd like to accept that offer, Your Honor.
All right, Mr. Cyrus, please raise your right hand. Do you swear or affirm to tell the truth? Gotta turn them, okay,
I'm sorry, Judge, that's my fault.
that's okay. All right, Mr. Cyrus, is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it will subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, Mr. Cyrus, adjudication time served. I give you 6 months to pay your court costs and no return to this location. You understand that?
Yes, ma'am.
Okay. Shane Mahabir. All right, Mr. Mahabir is before the court, one charge of assault, 2, 3, and 4, touch or strike battery, for which I find probable cause. And I'll hear from the parties.
Your Honor, the defendant has a 2017 petty theft, a 2017 battery, 2016 resisting without violence, another 2016 battery arrest, a 2014 battery arrest, a 2010 resisting without violence, and he was also arrested on that case for battery on a law enforcement officer. Your Honor, given the facts of this case and his priors, the state would ask for a $5,000 bond on counts 2, 3, 4, and a $500 bond on count 1. And no victim contact, as well as no contact with minor children.
Mr. Goldberg?
All right, if I can have just a moment. Judge, he's advised that the most that he can afford is the $300, which is what the convenience bond had been asking. He's lived here in South Florida his whole life. Again, he was going to be able to post the bond as listed. He just lost his job, and so he's hoping to start a new job soon. And so we'd ask the convenience bonds to remain in place so he can post them.
All right, what we have before us today is 3 separate incidents in 3 different locations, all within the same proximity of each other, and the alleged victims being minor children. And based on the allegations, I am going to impose a $500 bond on charge number 1 and increase the bonds on 2, 3, and 4 to $5,000. I am going to order, I don't know if this is I guess it is a shopping plaza. So I am going to order no return to the shopping plaza in Pembroke Pines, 11630 Southwest Second Street. All right. No, no contact with minor children and no victim contact. Christopher Ramisar,
That's North Broward, Your Honor. He refused to come down.
all right. Well, this is on a KPS where the judge already issued a $750 bond, so I find probable cause. We don't need to reset him. John Green,
She's on loan.
Mr. Green is on loan. Lee Tavius Gaines,
Main jail, Your Honor.
and Mr. Gaines is before the court on one charge of possession of cocaine. Number 2 is resisting officer without violence. Number 3 is a violation of felony probation. That has a no bond hold, and Mr. Gaines does have court scheduled with his division judge on the 6th at 8:30 a.m. I find probable cause, and the standard bond on one of $1,000 will remain. Jose Carvalho, Mr. Carvalho is before the court on one charge of aggravated assault with a deadly weapon without intent to kill. I find probable cause. Any word from the state?
He has a 2011 no valid DL, and out of Florida. I don't see any other priors out of Florida, Judge. The state's recommending a $7,000 bond based on the facts of this case and no victim contact.
Asking for $7,000 bond, no victim contact.
Thank you, Judge. Mr. Caravallo is eager to have his day in court. He very much disputes the allegations. He just moved, he's lived here in South Florida since 2003. He just moved from Miami in October. He now lives in North Lauderdale with his wife. He's self-employed as an electrician. In light of his employment, he's advised me that the most that he could afford is $1,000. We would ask that bond be set in that amount so he can post his bond.
All right, he'll have a $2,500 bond, no victim contact, which means no phone calls, no text messages, no social media, no third-party contact. Waldemar Allers.
Judge, Mr. Allers is approaching. The only thing that we would ask for him is that he says that counts 3 and 4, which I understand are not for the magistrate.
Right.
They're county civil holds. He says that they've been resolved. I don't know if there's anything that the court can do about that today, but
It's all been taken out from my paycheck every month, without a doubt. This actually from this county. I've been in my job for over 3 years, and it's been. I have everything that needs to be proven. Paycheck stuffs. I only take home, Your Honor, $387. Everything else goes to child support.
Here's the thing, Mr. Allers. They have, it's in the, I'm sorry? Right, they've received the information, over the system that says that there is a hold. I don't have that information. I don't have any access to Orange County information to make that change. So as far as there is a civil writ, they have bonds that are attached to it, $5,000 and $2,500 bonds on 3 and 4. That's from Orange County, so I don't have
And
any.
that's all child support.
Right, but I don't have any information about that, so that's something that has to be rectified otherwise, not here at first appearance. So I'll just leave everything in place on the driving while license suspended charge number 1. You have a $750 bond, and I'll leave that in place, okay? And
I'm
Prince, I'm sorry?
I'm sorry, yes, Your Honor. If, once, I get paid this $750, can, if this is something that cannot be taken care of here, can, Your Honor, expedite me, sooner so I can get to Orange County? I don't wanna lose my job. If anything that you can do on that matter, that'd be great.
Well, that's something that will happen automatically in the system. If you post the bond, then they will send in the information to Orange County that you're ready to be picked up, okay? All right, Isoan Prince. All right, Mr. Prince is before the court on 1 charge of possession of cocaine. 2 and 3. Number 2 is possession of drug paraphernalia. Number 3 is trespassing occupied structure or conveyance, for which I find probable cause. Mr. Prince has a $1,000 bond. What was
Judge,
that?
I didn't know if you're speaking for us or for the state. I'm ready to proceed.
Okay, go ahead.
Okay, Judge, we're gonna ask for a pretrial release for Mr. Prince. He's lived here in South Florida his whole life. He lives in Deerfield with his father. He's not working, but he also has some family in the area, so he's unable to afford the $1,000, and so we'd ask for standard pretrial release for him.
Does Mr. Prince have priors?
Yes, Your Honor, the state's asking for, on count 1. Judge, his priors are a 2017 possession of cocaine, 364 days jail, 18 months, prison and 18 months probation. 2015 possession of cocaine, 3 years probation, 364 days. 2011 cocaine, sell, deliver, 8 years, and he's deemed a habitual offender. 364 days also.
Mr. Prince has a $1,000 bond that I'm going to leave in place. Taylor Montelos.
He's coming up now, Your Honor.
All right, Mr. Montelos is before the court. Charge 1 is leaving the scene of a crash involving damage to property. Number 2, reckless driving. Number 3, fleeing with disregard of safety to person or property. Number 4, driving while license suspended, 3rd or subsequent offense. I find probable cause for these charges. State. Mr. Goldberg, while we're waiting, you can go ahead, please.
Sure, Judge. Mr. Montillas advised me he's lived here his whole life in South Florida. He lives in Miami right now with his mom and his dad. He does seasonal work. He works in a warehouse, but now that the season's over, he's not working. So he's gonna have a difficult time posting any bond here. So we would ask for the lowest reasonable bond that can be set.
He's gonna be on the PM docket for the ad charge. Okay. All right, so, as to, charge number one, I am going to increase the bond to $5,000. He has a $100 standard bond on number two, a $2,500 bond on three, and he has a $750 bond on four. And I'm been told that he's being ad charged, that he'll be back this afternoon for a hold in, where did you say? In Georgia. Joseph Petrie. All right, Mr. Petrie's before the court. Charge, one is petty theft. Third or subsequent offense. Number two is petty theft. Number three is burglary and occupied structure unarmed.
Judge, the defendant has a 2010 burglary, 30 days, prison and 2.5 years probation. 2007 Grand Theft Auto, 15 months prison. 2005 possession of cocaine, 270 days in prison. 2005 petty theft. 2004 possession of cocaine. 2003 resisting without violence. 2001 dealing in stolen property, 15 months prison. And then 1997 dealing in stolen property, 13 months prison. Your Honor, the state will be asking to increase the bonds on count one to $5,000, count two, $5,000, and count three, $7,500. And no return and no victim contract.
Judge, Mr. Petrie is asking the court for pretrial release. He's lived here in South Florida for the last 35 years. He lives with his wife in Deerfield. He's lived there for the last 3 years. He also has a brother in Oakland Park. He's not working right now. He was working as a barber, but he's not presently working. So he is asking the court to place him on pretrial release.
All right, these charges are as a result of two separate incidents on January 1st and then on January 2nd. The MO alleged is similar with the taking of bicycles from two different places. And based on that, did you say his most recent arrest was 2010?
2011, Judge, for uttering a forged instrument. He was adjudicated
2011?
guilty.
Okay, all right. So I am going to impose a $750 bond on charge number two. The $750 bond on one will remain. Then there's a $750 bond on two. And then on charge number three, return to these locations. James Johnson. Mr. Johnson is before the court on one charge of possession of cocaine. Number two, possession of drug paraphernalia. Number three is a traffic infraction not for magistrate. I find probable cause.
Nothing to add from the defense, Your Honor.
All right, he has a $1,000 bond. Jason Terrell. Mr. Terrell is before the court on one charge of possession of cocaine And number 2 is a misdemeanor capias. You didn't show up for court on December 19th for arraignment. The charge there is trespassing. I find probable cause. You have $1,000 bond on one, and you have $100 on the capias. And you have court on Monday at 9:30 a.m.
Judge, Mr. Terrell is asking for standard pretrial release. He's lived here his whole life. Unfortunately, he's homeless. He lives here in Fort Lauderdale. He's not working. He does have a mom in the area, though. And so he's asking for standard pretrial. He's not going to be able to afford this bond.
All right, I'm going to deny that at this time.
Your Honor, the defendant has 2 pending cases, one for trespass and the other for failure to leave property upon owner.
Okay.
He has a 2018 possession of cocaine, 2018 possession of drug paraphernalia.
Gregory Saunders.
Go with Broward.
Good morning, Your Honor.
Good morning, Mr. Saunders. You're before the court on 1 charge of grand theft auto, and number 2 is operating without a valid driver's license, and I find probable cause.
Judge, I'd ask you to keep the bond in place.
Does Mr. Saunders have any priors?
Yes, Your Honor, he has a 2018 burglary, 2018 grand theft, 2018 no valid DL. He did 18 months probation, 2018 grand theft auto, 2018 dealing with stolen property arrest, false ownership upon item, 18 months prison, 2016 burglary, 18 months prison, 2018 possession of cannabis, drug paraphernalia, 2017 no valid DL, 2017 no valid DL, and 2017 DWLS.
Mr. Saunders' bond is going to be increased to $2,500 based on the allegations in the probable cause affidavit and no return to that location.
So you say how much the bond is again?
$2,500.
That's $250 in percent. Okay.
Dela Juan Tullis.
That's $250, right? Hold on.
All right, Mr. Tullis is before the court. Charge 1 is a felony capias with a no bond hold and not for magistrate. 2, 3, and 4 are traffic capiases. Those all have $500 bond, $250 bond, a $500 bond. I find probable cause. It looks like you have court with your felony judge on Monday at 8:30 a.m. And on the misdemeanor cases, you have court on the 7th. Mark Sands. Sands is before the court for possession of cocaine. I find probable cause.
Judge, he's advising he can afford that bond.
All right, he has $1,000 bond. And then Dontavis Bryant. Mr. Bryant is before the court on 1 charge of neglect of child with great bodily harm. Number 2 is possession of cocaine. Number 3, driving a license suspended, second offense. Number 4, accident, unattended vehicle property without leaving ID. Number 5, child restraint. Those are traffic infractions not for magistrate. There's an expired tag. That's also a traffic infraction. Number 7 is careless driving. It's a traffic infraction. And then number 8 is a civil writ, which is also not for magistrate. I find probable cause for these charges.
Your Honor?
Yes.
Currently on pretrial case number 18001429 CF10A for possession of cocaine with intent to deliver or sell. Pretrial is asking that you revoke his pretrial.
When was he placed on pretrial?
Pretrial July 3rd by his division judge, Judge Merrick.
Is he in Is he in Veterans Court or is it the regular division? That's a regular division. All right, all right, as to the case number 18001429 CF 10A, pretrial is asking that your bond be revoked. I am going to grant that, and I will impose a monetary bond of 25, it's a possession with intent to sell, with a $5,000 bond. Okay. And as to the new arrest,
Judge, Mr. Bryant's advised me he's lived here his whole life. He lives in Pompano with his mom. He also has brothers and sisters. He's not working. And he's told me that the most he thinks that he could afford at the most was $5,000. Obviously, you'd have to post that on the other case. So he'd ask the lowest reasonable bond for count one.
all right, these allegations that we have, are that Mr. Bryant is in an accident. He has 4 minor children in the vehicle, that, I guess child restraint was, required, and that there was none, since he's received a ticket for that. And that he left this, he was found 3 blocks away from the scene, of the accident. He ran from the scene, leaving the children behind. One child, sustained a broken arm as a result of the accident. So, on charge number 1, I am going to impose a $7,500 bond, and then the other bonds will remain in place. Oscar Mendez. Mr. Mendez is before the court on one charge. Charge 1, make or alter prescription. Number 2, fraud, use or possessing ID of another person without consent. Number 3, unlawful possession of personal ID of another. And number 4, obtain controlled substance by fraud. I find probable cause for these charges.
Your Honor, the state shows no priors out of Florida.
Okay?
The state would recommend the bond stay as is.
Okay.
Judge, Mr. Mendez is telling me that he's 19 years old. Excuse me, he's not 19 years old. That he's lived here for the last 19 years. He lives in North Miami. He works doing mobile car detailing. He's living with some friends right now. His mom lives in the area, as well as his brother and some other friends. He's going to try to post bond. He's hoping the court will reduce the bond by maybe $1,000. If the court's able to do that, he thinks he'll be able to afford the bond.
Your Honor, the booking report shows that he has 0 months of residence here. He's
All right, here's a pending case out of Wyoming from 2019. I am going to deny his request to reduce the bonds and leave the bonds in place at this time. Okay. Alberto Salas.
Mr. Salas is a medical reset judge,
Okay.
and he is also on our second look docket for this afternoon.
Well, we'll see if he, usually,
See if he feels better this afternoon?
yeah,
Okay.
usually the second look, makes him feel better. Iram Domingo.
Judge, I was told I think that he's in regular court today, 6156.
Okay, all right, so we have to reset Mr. Domingo, for his ad charge. And then Peter Metzler.
North Broward, Your Honor.
All right, Mr. Metzler. Mr. Metzler is before the court on a petty theft charge. It's a felony petty theft, so it's a third-degree felony. I find probable cause.
Judge, I spoke with Mr. Metzler's cousin, and she says that he could be released to her custody. She's trying to contact Mr. Metzler's mother to see if he can stay with her. But it does appear as though he would have a stable residence if the court would consider releasing him to pretrial release. He's been living here for since he was 9 years old, and although he has had prior contact with the criminal justice system, I would ask the court to consider pretrial release for him.
Has Mr. Metzler ever been on pretrial? I know he's been before this court before, but
Judge, he does have a pending 2019 case, a criminal mischief and a trespass.
so I'm gonna deny the pretrial request. He has a $750 bond. All right, Roderick St. Rose.
Could I ask a question?
All right.
My attorney?
All right, so Mr. St. Rose is before the court for change of charge. All right, so on Mr. St. Rose, I have 4. I have 4 on the determination form and 4 on the original. All right, I made a copy of the original probable cause determination sheet that was signed by Judge Gottlieb. And at that time, when Mr. Rose, St. Rose came before the court on November 27th, the charges at that time were attempted felony murder, specified felony, which is 1 and 2, and number 3 and 4 was aggravated battery with a deadly weapon. Now that there's been a change of charge, the information has been filed, and there's been filed as attempted murder in the first degree, 1 and 2, and then 3 and 4 are aggravated battery with a firearm. So when Mr. St. Rose came before the court before Judge Gottlieb, he was on a no bond hold on 1 and 2. $10,000 on 3 and 4, and I am going to leave those in place at this time. Okay? Was that all part of that? Whatever it was. He was on, okay? All right, so those conditions are still in place, 3 and 4. There'll be a level what? Level 1? No victim contact, and a 500 feet stay away.
I'm sorry.
Sir, just so you know that all the previous conditions still remain in place. So no victim contact, you have a 500 feet stay away order, and if you post your bond on 3 and 4, it'll be a level 1, you'll be on a level 1 pretrial, okay? And no weapons or firearms.
I don't even know the people that was saying. I'm sorry about that, Judge.
No, that's okay, Robert Bukowski.
Mr. Bukowski, come on, sir.
All right, Mr. Bukowski is before the court. Charge 1 is dealing in stolen property. Number 2 is dealing in stolen property. 3 and 4, false owner information for pawn items. And I find probable cause. I'll leave the standard bonds in place. He has a total of $4,000 in bonds.
Judge, he's asking if the court can reduce those bonds. He is working right now in a call center. He's also in a halfway home. He's in recovery, and so gonna have a hard time posting these bonds. He would also ask the court for a phone order so he can get access to his contacts to try to find someone who can help him post his bond.
All right, I'll sign the phone order. I'm leaving the bonds in place. Lucien Joseph,
North Broward, Your Honor.
How you doing?
Mr. Joseph, you're before the court. This is for an ad charge. Is it an ad charge? It's a change of charge. I'm sorry. All right, so it's a change of charge. The charge is now burglary on occupied dwelling unarmed.
Oh,
No,
Yeah.
that's supposed to be burglary for dwelling. That's what the information that's filed says. Burglary for dwelling, okay. And, how much bond did he have before? All right, so I will leave that $1,000 bond in place. And Mr. Joseph, it looks like you have court before your division judge on Monday at 8:30 a.m., okay?
alright.
All right, are we ready with, Mr. Polito?
Yes, we are, Your Honor.
All right, so Mr. Polito is before the court on one charge of domestic battery by strangulation. It's dating relationship.
Judge, the defendant has a pending 2018 trafficking in oxycodone, possession of cocaine, possession of cannabis with intent to sell, possession of THC, possession of drug paraphernalia. And he has a prior arrest for aggravated battery, great bodily harm against the same victim in this case. It's from 2017. He has a 2011 criminal mischief, 2012 possession of meth, 2012 possession of another controlled substance, where he did 5 years state prison. The 2009 possession of cannabis and possession of concealed weapon, 2009 burglary, 60 months state prison. Grand theft, 4 years probation. 2008 burglary, grand theft and resisting without violence, 65 months prison. Your Honor, the state's asking for $10,000 bond with no victim contact.
Currently on pretrial in 2018 case 18014035 CF10A. Pretrial is asking that you revoke his pretrial.
Judge, from what Mr. Polito has told me, he's moved out of the residence and he lives with his mom. He lives in North Lauderdale, so he does not live with the alleged victim. He's lived here in South Florida since 2004. He works as a barber full-time. He does part-time work for construction. He's unable to afford that $10,000 bond, and he's expressing that he's very concerned about his children. So he's asking the court to set a lower reasonable bond than the $10,000 which the state is asking for.
Well, when was he placed on pretrial on this other case? Incident since then? All right, on case number 18-014-035 CF10A, I am going to grant pretrial's request to revoke the pretrial on charge number 1. I am going to impose a $7,500 bond. On number 2, a $1,500 bond. On number 3 and 4, also a $1,500 bond. And as to this new arrest with the domestic battery by strangulation, I find probable cause. I am going to impose a $10,000 bond. And no victim contact, which means no phone calls, no text messages, no social media, no third-party contact.
I'm sorry, Judge, what was the bond on this one?
10,000.
Thank you, Your Honor.
All right, I believe that brings us to the end of our morning docket. Thank you, everyone, and I will see you at 1 p.m.